My lady, the first issue about urgency is that the applicant desires this honorable court to deal with the illegal conduct of the first respondent as expeditiously as possible. The proceedings themselves are inherently urgent in the sense that they are linked to an urgent appeal in the Supreme Court of Appeal. Now, every day and every hour, a minute or second, the applicant is out of work, he's prejudiced. It's not only that there's a continued payment of his salary, that a high-profile person like the applicant, the head of the DBCI, remains out of work, and there are certain press statements in the media made by the employer, humiliates the applicant, and the applicant wants that illegal conduct of the first respondent to be stopped forthwith.
So the prejudice more on the humiliation?
No, it's a deprivation of an opportunity to work, to engage in work in terms of the contract entered into between the employer and the employee. And that is the most important aspect, my lady, because if your ladyship were to strike out this application today, it will be tantamount with respect to saying that the illegal conduct, perpetual illegal conduct of the respondent, which is occurring daily since the day of the filing of the appeal, should be condoned. It should be swept under a carpet, and nothing should be done. So when the applicant goes to the Supreme Court of Appeal on the 2nd of June, his appeal remedy remains unprotected. He is not in a position to go back to work because of the illegal conduct of the first respondent by refusing to allow him to go back to work. Now, with those submissions, my lady, we also add by saying that the reputational harm to the applicant is quite pervasive, and it should be dealt with in favor of the applicant. And the applicant has also mentioned the humiliation of the conduct of the first respondent in the national television concerning the conduct of the applicant. And these are the utterances, my lady, which need to be desisted forthwith to enable the applicant to prepare his appeal properly. My lady, those are the issues which are intended to deal with.
My lady, I propose to deal with three aspects, my lady. And before I do that, may I hand up to your ladyship?
Short further argument, my lady, together with a reported judgment. I have copies for our learned friends. My lady, I propose to deal with three aspects: urgency, the merits, and finally the concept of specific performance. With your leave, may I start with the merits? Your ladyship knows that subsequent to the launching of this application, the full bench of this division furnished its reasons as to why it gave the orders, which are to be found at pages 60 and 61, namely pending any further appeal or pending a petition, the operation of the full court's decision that he cannot go back to work should remain valid. Now, my lady, when one looks at the reasons, and my lady, before I deal with the reasons, may I ask your ladyship to look at the further argument? In paragraph 1, we point out, my lady, that section 70CA provides that the minister, with the concurrence of the cabinet, shall appoint a person who is a South African citizen, and secondly, which is crucial in this matter, a fit and proper person with due regard to his or her experience, conscientiousness, and integrity to be entrusted with the responsibilities of the office concerned as the national head of the directorate for a non-renewable fixed period of not shorter than 7 years and not exceeding 10 years. And your ladyship will see then, I've just cited a number of the provisions to view and consider section 18.4 in context. Your ladyship will see in terms of section 17C 12A, whenever the national head of the directorate is absent or unable, the operative word here being unable to perform his or her functions, the minister shall appoint a deputy national head of the directorate as the acting national head of the directorate. Section 12C provides that if both the national head of the directorate and the deputy national head of the directorate are absent, the minister shall appoint a suitably qualified and experienced person as the acting national head. And finally, Section 17D deals with the functions of a directorate. It is clear that from its provisions that it is not the functions of the national head of the DPCI, but that of the directorate. In short, the national head or the national deputy head is dispensable because the acting national head of the directorate becomes responsible for the proper execution of these functions of the directorate as contemplated in Section 17D of the same Act. Then, my lady, in paragraph 4, I deal more fully with the reasons that came after the launching of the application. The full bench of this division found the applicant, Mr. Ntlemeza, as not a fit and proper person to hold the office of the national head of DPCI. That's in the judgment, paragraphs 34 to 42. This is an objectionable jurisdictional fact, and that your ladyship knows was pronounced by the Constitutional Court in the well-known case of Mr. Simelane, reported as DA versus President of the Republic of South Africa, in its reasons for granting the order that the operation and the execution of the order shall not be suspended and will continue to be operated and executed in full. The full bench points out that the finding of Mr. Justice Matujana that the applicant to be dishonest, duplicitous, dishonorable, and to have acted in bad faith and or ulterior motive is final in the context that the SCA dismissed the applicant's appeal against those findings. Now, my lady, if I may just pause and tell your lady to summarize why, with great respect, our learned friend's reliance on Section 18.4 is misplaced. What had happened, my lady, when the matter came before the full bench considered two applications. One was an application for leave to appeal. That application was dismissed, and the order is to be found at pages 58 and 59 of the papers. But the full bench also dealt with a counter application. And the counter application says, if this applicant is going to lodge a notice of appeal to the SCA or the Constitutional Court by way of petition, then we want the full bench to pronounce that he cannot go back to work pending any such appeal. And the reasoning of the full bench is to be found in paragraphs 9 and 12 of the judgment, which we handed up to your ladyship early this morning, the reasons. What they say, what the full bench there says, which with great respect our learned friends have not addressed, is this. They said that in 2015, Mr. Justice Motijani found this particular applicant to be a person that's not fit and proper to hold that office. The applicant then petitioned. He was refused leave to appeal by Mr. Justice Matujani, but he petitioned the SCA. The SCA declined the petition. So reasons the full bench. They say, you have a High Court judge finding the man is not fit and proper. Once he's not fit and proper, that's final because he appealed. The appeal was refused. He didn't pursue that any longer. Now what they say, by reference to the judgment in the Simelane case, they say that that is a jurisdictional fact. In other words, he hasn't got the capacity to fill the post. Your ladyship will recall that what happened in the Simelane case, if it's necessary, I can take your ladyship to the facts. But what had happened, my lady, is that the SCA found that the reliance by the president on what was told to him about Mr. Simelane demonstrated that he didn't apply his mind when he appointed him as the National Director of Public Prosecution. There was a Givala Commission of Inquiry. The Givala Commission of Inquiry referred certain aspects in the cross-examination of Mr. Simelane to the Public Service Commission. The Public Service Commission then is required, and in fact Professor Sanguini, who was the chairman of the Public Service Commission, invoked the provisions of the Public Service Commission to hear the matter. But in the interim, Mr. Simelane was appointed as the National Director of Public Prosecutions. And when the court looked at all the facts, the court found that although the power to appoint him is given to the President, the fact that he is not fit and proper is an objective factor. And if he hasn't got it, then statutorily you can't appoint him. And my lady, I've handed up to your ladyship a judgment of Mr. Justice Corbett, as he then was known as the South African Legal Aid Defence Funds case, versus the Minister of Justice. Because, my lady, at page 4, this judgment went on appeal, but the appeal did not disturb the findings at page 4. What Mr. Justice Corbett finds is that when a statutory power is entrusted in a public official to make an appointment, and there are certain objective criteria that fills that particular position. In this particular case, a certain state of affairs had to exist before the then president make a declaration in terms of the then Suppression of Communism Act. But the point, my lady, is that the fit and proper test is a jurisdictional fact which is objective fact. So, my lady, the full bench of this division considered that... Yes, my lady.
Those are issues that could be considered by the court.
Yes.
But I'm not competent. The court is not competent to even.
My lady, the only point I want to make, and I'll move on, the only point I want to make, Section 18.4 cannot have application when a jurisdictional fact has not been met. That's the only point I want to make. That is why the full bench, my lady, faced with a counter application, and they know the provisions of Section 18.4. 3 judges of this court, my lady, they know it. And they, despite that, my lady, and as your ladyship pointed out to my learned friend, the wording of that order is clear. Pending any appeal to any other forum.
No, I was referring to the provisions.
But my lady, but perhaps I just take your ladyship to that particular order, because I then move on, my lady. If your ladyship will turn to page 60, my lady. Your ladyship will see at page 58, on the 12th of April 2017, the full bench refused the leave to appeal. Then on the same day, my lady, page 60 and 61, paragraph 2, the operation and execution of the order granted by this court under case number 23-199-16 on 17 March 2017 is not suspended and will continue to be operational and executed in full, whether or not there are any applications for leave to appeal and appeals, or there is any petition for leave to appeal in respect of this order. We submit, my lady, the minister was quite correct, my lady, when he says, I want to give effect to an order of this court. And my lady, when you look at the reasons that the full bench provides is that this person simply doesn't comply with a jurisdictional fact to hold that office. So we would submit, my lady, in context, Section 18.4 has no application. Then, my lady, I want to then deal with the second aspect, my lady, and that is urgency. I'm sorry, my ladies, the concept of specific performance. Now, my lady, we make the following submissions. The applicant is on full pay. His hearing, and this also goes to urgency, his appeal, my lady, is set down for the 2nd of June. When this application was launched, we had no knowledge when the appeal would be heard. But what they're now doing, my lady, they're coming here, my lady, with the greatest of respect, to score power politic points. The matter is going to be 2 weeks from now in the SCA. The matter will then be fully ventilated. Until then, my lady, there's an order of court. Public perception, there's an order of court that he can't go back to work. And I'm just going to quote that one paragraph, my lady, of the full bench division, and then I'll leave this particular point. They say the following, my lady. When your ladyship turns to the reasons provided by the full bench, my lady. Your ladyship will see in my heads of argument, I say, my lady, that consequently the remarks have now become dispositive of the facts, and that is, my lady, that he is not fit and proper. And then if your ladyship will turn to the actual judgment of the full bench, your ladyship will see in paragraph 11. This is what the full bench says. It says in paragraph 11, Mr. Colin Rajab, on whose supporting affidavit the application relied in this counter application, testified that our constitutional democratic system cannot tolerate Mr. Ntlemeza remaining in office any longer. The prospect of him continuing to occupy that office, someone whom the Superior Court has pronounced lacked honor and integrity, and who was at all material times disqualified from being appointed to the highest office, is inconsistent with the provisions of Section 17CA of the South African Police Service Act. His continued occupation of that office in the face of a lingering remarks made by a superior court will unavoidably cause irreparable harm to the administration of justice, the ongoing cases, the public and the public perception. The findings against Ntlemeza have now become public knowledge. What impression is the perception of the public will have if Mr. Ntlemeza's continued occupation of this office create? Now, my lady, with the greatest of respect, my learned friend says, my client has been bellicose, my client has been very vociferous. He has to be very vociferous, being the minister in charge. It's no difference, my lady, on that issue, and I'll leave that issue, my lady, if a court pronounces that a teacher is a pedophile. And my lady, the court makes a finding to that effect. And then there's a section in the Act which says, pending an appeal, he must come back to work. One can imagine how incensed the school principal is going to be to put that person back to deal with children. So public perception, my lady, it's a value system, it's a relative concept. So under urgency, my lady, we submit, my lady, he's on full pay, the matter is 2 weeks away. We submit, my lady, that in his amended relief, he's not dealt with irreparable harm, he's not dealt with prejudice, he's not dealt with convenience. So the amended section prayer 4, which says, put me in back pending my appeal, he comes hopelessly short in terms of the test, my lady, in the Setloga case or the Webster versus Mitchell case. He had to deal with, my lady, his prejudice. He doesn't deal with prejudice. And finally, my lady, on the specific performance, my lady, we've given your lady a number of references on the concept of specific performance. What my ladyship, what my learned friend is arguing is to say this is a status application. I want the status that until the 2nd of June, I'm in the office as the head of Hawks. Now that's a status. He's got to make out a case for status, my lady. And the authorities are clear, my lady. I've given your lady a reference to Stewart Ribson versus Top, a judgment of the then appellate division, which is to the effect, my lady, one must demonstrate that you are worthy of that office. And my lady, there is a very good case in labor law judgments, my lady. It was a professor in Zimbabwe, where his employer said to him, look, Professor Mazondo, here's your 6 months notice, go sit at home. The courts reinstated the professor because the court said the professor's job entails him using the library, having access to the students, using the resources of the university. But the professor made out that case, my lady. In these papers, they don't make out a case whatsoever why his status is affected. And his status cannot be affected, my lady, because we know there are at least 4 judges in this division, if not 5. If a proper reading of Mr. Justice Tuchten's judgment is a credibility finding against him, then there are 5 judges. The 3 judges in the full bench, Mr. Justice Motojani. So at least 4 judges, my lady. Without hesitation, I can say to your ladyship, found this man to be dishonorable, not fit to hold that office. And I don't want to use more graphic language that they use. But in the face of that, my lady, How can he say, how can my learned friend make the submission that there's a degradation of his status if he's not back at work? He's lucky he's being paid, my lady, whilst his appeal is pending. With the greatest of respect, my lady, on the merits they have a problem. This is not a straightforward section 18.4, and I accept your ladyship. We don't have to argue the subtle arguments, they can be determined in another forum. But on urgency, he must fail, my lady, because as long as those judgments stand, they have a full effect until they set aside. So he doesn't succeed on status. All that section 18.
I think the challenge is that both of you will have different interpretations of paragraph 2 of the judgment.
I accept that, my lady.
You're not on the same page.
But my lady, one thing, my lady, at best for him, under section 18.4, at best for him is to say, until my appeal is heard, I'm entitled to my salary. Well, he's being paid his salary, my lady. If he's fighting about cell phone in a motor car, we can talk about that, but that's hardly anything that should border. My lady?